and kick it off.
Good afternoon. Thank you everybody to being here with us today. My name is Veronica Alvarez, and we have here with us again, Alison Schaberg from Consolidated Planning Group. Thank you for being here. And also we have a special needs attorney, Lisa Wilson. Also, thank you for being here. Before we start our presentation, especially planning planning trust webinar, I'm going to talk to you guys a little bit about Partner Resource Network. So I'm sharing my screen. All right, so who we are, Partner Resource Network is the parent training and information centers for Texas. You can hear like we are the PTI of Texas, and we are funded by the Department of Education, Office of Special Education. We provide free resources and training for parents of children with disabilities and self-advocates. Our mission is to empower and support the families impacted with individuals with disability or special healthcare needs. So we serve parents of children and youth with disabilities from the ages from 0 to 26. Partner Resource Network was first founded in 1986 and is now comprised by 4 projects. I'm part of the team project. As you can see in the map, we are in the red area. So Region 13, Austin area, is part of the team project. We also have Region 20, that's San Antonio area, and Region 1, that is the Rio Grande Valley area. And in each part, in each region, we have a regional coordinator that helps parents. So if you need to know which coordinator is the one that is serving you, please just send an email and we can contact you with your regional coordinator in your area. Our services are free, and we offer parent workshops, youth workshops, webinar like this one, information and referrals, one-on-one technical assistance, and we do a lot of our phone calls are about IEP support, IEP clinics. We support you guys also in the ARD meetings. Once a year, we do a symposium. We offer training in leadership for parents and for youth. So for today, if you have questions, please use the chat box, and we will answer the presentation, the questions along in the presentation, not at the end. So Allison is going to be monitoring the chat, and also myself, but mostly her. And if you need the recording of this presentation, we are going to have it later on in our Facebook pages, and also it's going to be posted in Consolidated Planning Group YouTube channel. Allison is also going to talk about it in a moment. And at the end of the presentation, we are going to have, you are going to receive a link for an evaluation. Please, we take the time to fill that evaluation. We appreciate you guys to help us with honest feedback. We do not provide CEUs, but we can give you guys a certificate of attendance. If you need one, please just put it in the chat box or email me, and I can do that for you. Again, this is my contact information. I'm Veronica Alvarez, Regional 13 Coordinator for Partner Resource Network. This is my phone number, my email. Notice it's a new email, region13prn@gmail.com. And our webpage is www.prntexas.org. So welcome everybody. And now I'm going to stop my sharing. And we are going to have Allison talking about Consolidated Planning Group. She is a passionate advocate for the special need community. She's also a parent of children with special needs and understand our world very well. So she's a licensed financial planner with a lot of experience. So welcome, Allison. Can you unmute, Allison?
Yep, sorry, I was just having a little bit of technical difficulty, and I'm going to share my screen right away. And let's see if we can go to, whoops, hang on. Try that again. Bear with me 1 second while I pull that back together. So Allison Skalberg here, Consolidated Planning Group. If you're here back with us for the for one of our presentations, we're glad to have you back. If you're joining us for the first time, we have partnered with Partners Resource Network a number of times for a number of presentations surrounding special needs and special needs planning. I am a parent. I am a parent to 4, and I have 2 kids that have special needs. And so what I would say is that it's navigating these waters is sometimes tough, and there's basically a lot of things that we really need to know. And when you're kind of in this phase of transitioning, there's so many things that are kind of going on and all these moving parts. And what I would say is, when I was doing this with my adult child, when we were kind of doing this, it was tough. It was difficult. This is what I do for a living. I eat, sleep, and breathe this. I live this. I work this professionally, and I would say it was tough. So we really strive to put out a lot of webinars, educational events, and we partner with other organizations and professionals such as Lisa Wilson to get some of this information out. But what I want to share before we turn everything over to Lisa, today we're going to be talking about special needs trust and some considerations that you might need to be thinking about. The why behind it, what you need to know about kind of special needs trust is what we're going to be talking about. But a lot of times there's some confusion on what is Lisa's role, what is Allison's role. Do I need both of them? I'm confused. People call Lisa and probably ask if she does the financial side, and people call me and ask if I do the legal side. And so the truth is, we're special needs planners. Okay, so I like to say that Lisa and Lisa's group, there's a legal documents, there's a legal questions, there's a paper, and we're the money. And it's money in the right buckets, and you have to have the right buckets established, the paper with Lisa's office, to be able to have money in the right buckets when it comes to special needs planning. And that, I just said a lot in a very little short period of time, and we're going to go into more details on that. But that's kind of where it comes into play, where you might need a special needs planner. Special needs planner is nuanced than the special needs rules and laws and other things that may cause your loved one to lose benefits, whereas other financial advisors and things like that, they have similar licenses that we do, but they're not nuanced in special needs. Same thing with an attorney. One of the things that I say when it comes to special needs is this is not a do-it-yourself kind of thing, okay? You have a specialized situation, and there are many attorneys out there that can do things, but that's not what they're specialized in. And there are rule changes. There are a lot of laws that attorneys that specialize in this type of law are really adept in, and that's who you want to be working with. So when you're thinking about your planning options, just like, if you have a specialized situation, you have a heart condition, you're not going to go to a PCP and have them check out your heart per se. You're going to go see a specialist. And I think that's the same for this as well. So having said that, I'm excited to have Lisa Wilson with us from Hays and Wilson. I'm going to turn it over to you, and I'm going to let you introduce yourself and kind of your background.
Okay, sounds good. So my name is Lisa Wilson, and after hearing Allison's talk there, I think it makes sense to say I'm also a parent. I have a daughter with Down syndrome. She turned 34 2 days ago, and she's kind of the reason I got interested in this practice area. So I've been doing this for right at around 25 years. So today I'm going to talk about special needs trusts, and I guess the next slide, Allison, because I've got the questions up there. So people are confused about what a trust is. And it really is helpful to look at it as an agreement. So generally the person making a contribution to the trust, putting assets in there, is going to be the grantor. Sometimes they're called the trustor. I can see that I wrote that wrong. It was supposed to be trustor, not trustee. So it's the grantor and the trustee. So assets are transferred to the trustee, and the trustee holds those in trust and needs to prudently invest them, manage them, make sure they're productive, and then make them available to the named beneficiaries according to the instructions in that trust agreement. But it still is, it's almost a little different from just agreement, because we do talk about, you know, a trust almost like an entity. It generally will get its own tax ID number. It has to file an income tax return. So as those investments are made and it's generating income, that needs to be reported to the IRS. So while it's easy to understand when we talk about it in terms of an agreement, it sort of acts like an entity as well. So people often think that there always has to be an account associated with the trust, or that a trust is an account. And it really isn't. Now, a trustee may decide to place some assets in a bank account or an investment account, and that is totally up to the trustee. They have that full authority. So they may choose this financial institution for investment, but may decide later they're going to pull it out of there and put it elsewhere, or invest in something entirely different. That is all up to the trustee. Now, a special needs trust is one that is really designed to hold assets for the benefit of a beneficiary who may be on government benefits that are based on financial need, limited assets, limited monthly income. So a special needs trust is really designed so that the assets in the trust are not counted when determining the beneficiary's eligibility for benefits. So a lot of you may be aware that for a number of the Medicaid programs, there's a $2,000 asset limit. So nothing in the trust should be counted when determining the assets of the individual. These would not be considered the individual's assets, even if they're a beneficiary of the trust. The trustee then needs to be aware of what the various monthly income limits are for any program the beneficiary might be receiving benefits from. And in general, if the beneficiary is on a program with limited income cap, the trustee would not be giving cash to the beneficiary. That would be countable income. So SSI, I think that's the limit right now is $795 a month, I think. So we don't want the beneficiary giving, or we don't want the trustee giving the beneficiary $1,000 cash to pay their bills and have some spending money. That is over the cap of SSI. That would be countable income. That would make them ineligible. So you would, through the special needs trust, it's intended to address both the asset limit and the monthly income limit. The language of the trust would protect the assets from being counted against the asset limit. The actions of the trustee would make sure that any distributions would not be countable income.
So in regard to that, so basically what you're saying is that the trustee does not make distributions to the special needs individual directly, but on their behalf. For instance, the special needs trust could buy a car for the individual, or pay for car services, or pay for a vacation, or pay for any number of things. And we'll get into details of what a special needs trust can pay for. But it's not giving the money to the individual to allow them to pay for it, is basically the way to go about that.
Exactly.
Okay.
We see the trustee paying directly to a provider of a good or a service for the benefit of the beneficiary.
Okay, so are you ready for the next slide? Because I think
so.
your next slide is probably going to address some of the other things, and then we'll come back to some of the other questions.
Okay. It's very important to know that there are two different types of special needs trusts, and we just use that umbrella term as a trust that's intended to provide for a beneficiary but keep them eligible for benefits. So a third-party special needs trust is what we're usually creating at my firm when we're working with parents or other family members who want to provide for a family member with a disability who's on benefits. Third-party trust means anyone can put money into this trust other than the person with the disability, the person who is on benefits. And so the terms of this trust can be a lot looser than the next trust I'll talk about, the first party. And the grantor, again, the creator of the trust, the one generally that's going to be putting the assets in there, they can direct what happens to any remaining funds once the primary beneficiary dies. The trust terminates. They can direct if it would go to other family members or charity, wherever. A first party trust is a trust that under federal statute can be created if a person who is on benefits or contemplates being on benefits based on their disability and financial need, they can create that would allow them eligibility. Now, we call those, I put in parentheses there, the Medicaid Reimbursement Trust. We put that in the name of the trust just so everybody understands. What makes this one significantly different from a third-party trust is that it has to provide that upon the beneficiary's death, any remaining assets will go first to Medicaid to reimburse the state for the amounts paid out during the beneficiary's lifetime for their healthcare needs under Medicaid. So we never want to cross-contaminate these trusts. We never want an individual who is on benefits to put their money into a third-party trust. So this question comes up a lot with my clients. I'll be working with parents and we'll create the third-party trust primarily to be funded when the parents are deceased. While the parents are alive, they can provide those funding or those special needs for their family member, for their child. Typically, that's my typical client. It's going to be parents' special needs child. So if the child is receiving Medicaid or other benefits, the parents can supplement their life with purchases for goods and services. And the trust to some extent is to replace them when they die. Here's some funds we're going to direct over here into this trust. We're going to name someone to manage it, and they're going to continue to supplement that child's benefits by giving them a better quality of life. So at any point, we want to make sure, or at no point, we never want to put the child's money into that trust. And part of the review that Social Security or Medicaid would do would be to see where is the source of the funds going into that third-party trust. Are they all third-party funds? So again, we want to be very careful not to cross-contaminate.
Because we throw around, and you and I talk about these things all the time, first party, third party, and we know this, I just want to do a recap on kind of what you said. So basically, when a child has their own funds, it goes into a first party special needs trust. A first party special needs trust when it's their own funds. It could be a lawsuit, it could be a scholarship, it could be their own funds. That's a first party special needs trust. And there is a Medicaid payback upon the child's death. There is a Medicaid reimbursement, as you said in your slide, on a first party special needs trust. So so it's possible that a person doesn't even need a first party special needs trust. If the person doesn't have their own assets, if there isn't a lawsuit or this big settlement or some other things, Is it possible that a person may not even need a first party trust, Lisa?
Yes. Yeah. And so, farther down here, I'll give the circumstances where we're most commonly creating those first party trusts.
So one thing I also want to ask here, so, we say the usual sources for a first party trust is an inheritance, but can we clarify that a little bit further? So basically, if somebody leaves money to your special needs loved one outright, okay, as opposed to a third party special needs trust, can you clarify that a little? Because sometimes that gets a little bit muddled.
Let me walk through those, because again,
okay.
that's what.
Perfect.
So, no, back to the other slide.
Okay.
Sorry. That's a key difference between the two types of trusts. The other is the basic distribution terms. On the third party trust, I could write in there that I want my sister and her family to go to Disney World once a year and take my daughter with Down syndrome with them, and they can use that trust. A first party trust has to be a strict sole benefit. So only the person on benefits can receive benefits from those trusts. And how those trusts can be set up is prescribed by law as well. So typically, we're having to go to court to create those first party trusts because of that federal law. So as Allison mentioned, that there are the most common circumstances we see in my firm where we have to create the first party trust are really what I call sort of unintentional inheritances. And so we've gotten to where when we do a third party trust, when the parents are doing their own estate planning, we do a letter as a way to alert grandparents, other family members, if you're thinking about leaving anything to my daughter, Leslie, don't do it. Please leave it to this trust because that will protect her benefits. Here's the horrible things that we'll have to do if she receives money. Now, I've seen so many cases where especially grandparents, they just don't believe that. Well, how can this possibly be bad? I'm going to leave my granddaughter this piece of property that's been in the family out in Caldwell County, Texas, so she'll always have a place to live. And of course, that's not really practical. It's not helpful. And then we have to spend a lot of money creating this first party trust. So that's if the individual with a disability is named in a will or named as a beneficiary, it's theirs at the moment the person who owned it dies. Now, we have this wonderful change in our law in Texas now where we actually can go back and reform someone's will after they die to direct an inheritance into a special needs trust. And we've used that a bunch. It's great. The other common thing is personal injury lawsuits. Now, sometimes this is the reason why the person has a disability to begin with, because of a medical malpractice incident or a car accident. So sometimes if there's a lawsuit and a significant settlement, part of that agreement would be creating a court-created first party trust with that Medicaid reimbursement. And that allows the person to not have to use up all of the money they received in the settlement for their significant healthcare needs. They can get on Medicaid, they can get those benefits and still have this pool of funds to help improve their quality of life. Back benefits from Social Security is another one. I've had two that were really significant, over $100,000 when Social Security realizes they've underpaid someone for years and they get a lump sum. Social Security gives you, I think it's 9 months where they don't count it, but then they do. So you have to do something with it. So overall, it's the deal Medicaid makes. And overall, we think it's worth it to create that trust, even with that Medicaid payback. There's no requirement that you preserve assets in the trust in order to reimburse Medicaid. If it all gets spent down during the individual's lifetime, that's fine. There's no penalty for that. And if an individual has both trusts, we generally look to spending first when it's practical, the first party trust with that payback. So the funds that the family have set aside for the individual with a disability can go on to other family. So are there any questions there, Allison, before I move on to the?
No, not really. And I'll answer the other question that we have in the Q&A in a little bit. But one of the things, so the takeaway, if you're taking notes here, and this is a big thing in our practice that we see a lot, is this accidentally naming people as beneficiaries. So if you're married and you have a life insurance contract, and it's very common that a life insurance contract says, okay, if I die, my spouse is going to get the money. And if I die and my spouse is already dead and gone, then my kids are going to get the money equally. That's very common. So I mean, I would say maybe even half of the people that are on this meeting today may have things set up that way. It's very possible. So the big thing is naming your special needs child, and they get this money directly. But I also want to mention, it's not just your special needs child. When you have minor children that you name as beneficiaries, that money goes in trust for them basically, and they get all of the money when they turn 18, and most kids don't need that kind of money. So if it's left directly to a minor child. So there's a lot of better ways about going about doing this, and it's easily fixed. It's just a change of beneficiary form. But one thing I think that is also a common misnomer, Lisa, that we run into is people say, oh, I have that all taken care of in my will. And but when it comes to life insurance and beneficiaries and bank accounts and investment accounts, 401ks, 403bs, no matter what your will says, it's what the beneficiary designation is on those accounts is how that pays. So I want to make sure that everybody knows that. And then I really want you to talk about how in the state of Texas that sometimes if you're in a divorce situation that child support could continue past age 18, and which particular type of trust would that go into in the example that you have child support continuing past age 18?
So, family child support can continue beyond the age of 18 for child with a disability or adult child with a disability. I know that law has changed a lot over the years, but I think it's pretty broad now. And now, oddly enough, for SSI and Medicaid, child support is counted as income to the child. I think it's when a child is under the age of 18, 2/3 of the child support is counted as the child's income. And once they reach the age of 18, all of the child support is counted as the child's income. And that seems really strange because it goes to the parent, but the purpose really is to pay for the child's basic needs, what a parent would be providing. And so it should be, applied to that first. It really is, the benefits programs are looking at what assets, income are available out there for that child to pay for those basic needs, for their basic food and housing, medical care. So we have had successes in having in the court order for child support to have the child support paid directly to a first party special needs trust. So it has to be by court order, has to be a first party trust. Now, generally that's kind of okay that even with the payback, because child support typically gets used during the course of the month for what the child's care needs are. But it's a very different circumstance for the payee, the obligee, the parent who has primary custody, because before they might take a child support check and just lump it into the household budget. But now it's going into a sole benefit trust. And if Social Security, if the child's also receiving Social Security benefits, that should be applied first to the household expenses. So the trust distributions would be for special needs. And so, you know, it creates a different financial situation for that household. So if it is directed by court order, what Social Security determines is irrevocable. They'll consider that irrevocable, an irrevocable assignment to the trust if it's by court order. Then the child support is not countable as income. So for the benefits like SSI and Medicaid, which have monthly income caps, it would feasibly allow the child to be eligible for SSI and Medicaid and have those payments coming in from the obligor parent, from the other parent, to help supplement their care needs.
Couple things, Lisa. One of the things that you said that I think is real important is you said by court order. Okay, so we've had families ask us in the past, okay, well, can I just go into the child support system and just set up the checking account for the special needs trust? And yes, you could do that, but it's not right and it's not approved, right? Like, so you might be able to go in and navigate and change your checking account in that support system. But there has been some word on enforcement that once it is directed to the child support, once it's directed to the trust, that the child support enforcement. So there's a lot of kind of moving parts. Do you have any updates on any of that? Through the state?
Because I don't do family law, so honestly, I don't, that's not, and I'm
Sure.
very careful to say, I usually am brought in on a divorce, and I'm very careful to say, I know two things, basically, that we have to have it in the court order, and it has to be a first party trust. And
Sure.
I really don't know about the mechanisms for payment or enforceability. And I'm just real clear. I'll be happy to draft the trust and submit it for review to SSI or Medicaid. I say you've got to have that in the court order, but you know, that's all I know, and that's all that really that SSI has said about that. So if because a lot of people want to get creative. Well, what if I'm like, you're on your own if you want to get creative?
Well, and I guess that's my point, is like the court order is necessary. It's not this again, it's not a DIY project. You can easily get a court order. I mean, if you're getting the same money and you're saying, hey, listen, I'm not asking for more money, I just would like it to be directed to a special needs trust. You got two willing parties that will sign off on that, then it's easy to get a court order, those types of things. It doesn't have to be madness. But one other thing I wanted to mention, and the reason this is important, is that I have seen families before where they came in and they had qualified for SSI and Medicaid, and then had the child support that Social Security didn't know about. And then 7 years later, Social Security says, oh, wait a minute, you've been getting child support and this is income. And so just like you had the wonderful story where they owed them $100,000, I've seen the other story where the Social Security Administration has come back and said, hey, hold the phone, you owe us $80,000 because we've been paying you for the last 7 years. And so that's why it's important to get it taken care of on the front end. And as Lisa said, she's not kind of on the family law side or divorce law or things like that. But one thing that I will say, there are advocates out there. There are law firms out there that are specialized in special needs divorce. And again, if you are finding yourself in that situation, we hope you aren't, they're going to be very helpful and kind of navigating and putting, having things in place that are relevant to this topic. So I think we have a couple of questions. Okay, so you were talking about some of the benefits earlier, different programs. The one question is, do waiver programs benefits affect SSI benefits?
Well, SSI looks at income, and the waiver programs generally aren't paying income to the beneficiary. Now, they may pay a caregiver or, a parent in a host home sort of situation, but that's to the parent or the caregiver. That's not income to the SSI beneficiary. So,
I believe the number, we are National Social Security advisors, and I believe that the number is 300% of SSI. So like if you're on a waiver program and say you switch over from SSI to RSDI, so maybe mom or dad retires or they become disabled. So the number is 300% of SSI, because you want to maintain your Medicaid eligibility. So when you're on a waiver, you have to maintain your Medicaid eligibility. That number is 300% of SSI, which I believe is 2313. That number is 2313 for 2021. And another magic number for 2021, and we have a whole webinars on SSI and all these types of things. But the income, like the earnings based off of your child is no longer considered disabled. So if they're working and they earn more than the substantial gainful amount, or SGA, that amount this year for 2021 is $13.10 per month. So if they're working and they're getting SSI, their SSI is being reduced for their working. They're basically, you don't want them to earn more than $13.10 per month, or they basically could be cut off, completely and not considered disabled in the eyes of the Social Security Administration.
And
go ahead.
I was just going to say, a lot of my clients get stuck when they're transitioning from SSI to Medicaid because a parent retires and then they're getting greater monthly income, and they get the notice that they're losing their SSI and the automatic Medicaid, and they're already on a waiver program or on a list. They just reapply for the Medicaid under the DAC, Disabled Adult Child Benefits. There's a program that identifies that particular population, those individuals who are losing their Medicaid because they've lost their SSI because they now have increased income from their parent's record. A parent retires or dies. And so Social Security, when they make themselves available to some of our continuing education, keep saying they're going to get much better about telling people to do that instead of just saying, yeah, you're off your benefits at the end of this month. But so a lot of my clients get kind of alarmed and so just say, yeah, you just have to apply for the DAC.
Mm-hmm. Okay, so we have a couple beneficiary questions here. Can an inheritance go into a third-party trust?
Absolutely, but it has to be directly named. It can't name the individual with the disability and then they turn around and put it into the third-party trust, because the moment that person dies and the beneficiary has been named either in a will or on a beneficiary designation, it's already the individual's money, and they'd have to then create a first party trust unless we can go reform the will. So your beneficiary designations, your will wants to say, I leave a third of my estate to my daughter, Leslie. However, in my will, it's not going to go into her outright. It will pass directly to this trust that I have created for her benefit. Or in a life insurance beneficiary designation, IRA beneficiary designation, I'm going to put 1/3 is payable to the then trustee of the Leslie Wilson Special Needs Trust.
So I just want to say that again. So I always use the example of little Johnny. So if we, so let's just say that somebody leaves your son, little Johnny Smith. They leave him $250,000 to Johnny Smith's name. In that example, you're going to need to get a court order to get it put into a first party special needs trust. There's no way to disinherit that. I've asked people if they could disinherit it. What if they don't take the money? What if he gives the money to somebody else? And there's no way around that, because that question comes up every time. So if they leave it to Johnny Smith, in that example, you work with somebody like Lisa, they get a court order to get it redirected to a first party special needs trust. So the way to do this on the front end, the right way, is for the third party special needs trust for the benefit of Johnny Smith, or for the supplemental needs trust for the benefit of Johnny Smith, or it might be the testamentary special needs trust for the benefit of Johnny Smith. Any of those things are going to work and going to allow it to go to the third party special needs trust, but naming the child outright, there is no other way around it. It will have to go to the first party, is basically what you're saying, right? Okay, got it. Okay, so we have another beneficiary designation. Okay, so on a beneficiary designation form, can a trust be placed in lieu of the child with special needs as a beneficiary? And absolutely, trusts are named all the time on a beneficiary form. And one thing I will tell you, in my industry, on my side of the house, and the financial advisors and planners on the side of the house, a lot of advisors don't get in the weeds on this beneficiary stuff, and this stuff really, really matters for your specialized situation with your special needs child. So again, you know, and I mean, I've seen horrible beneficiary designations like the estate of the insured, or nothing, or just really, really bad ones all along the way. So again, if you're taking notes, just mark it down to put this on your agenda, because the thing is, maybe you haven't looked at this in 5 years. Maybe you've never looked at it closely. It's just something that you should revisit from time to time. Check your IRAs, your 401ks, your brokerage accounts, your life insurance, any type of old pension you may have had from an old company that may have beneficiaries on it. It's a good exercise to do. It is also a good exercise to do if you've gotten divorced, or you might have somebody on there that you don't want to be on there anymore, because again, it doesn't matter. What your will says is what your beneficiary says. So just, you know, just mark it to check it. And if they're wrong, you can get a free change of beneficiary form, and you can update that with the insurance company. You don't have to pay somebody like myself or Lisa to do it. We can do it for you. You can pay us to do that. But you definitely can, you can definitely update those yourself. And a lot of them you can download yourself. So let's see, I think I have, and this is a good question. I do get this one. Can an inheritance go to an ABLE account?
Well, yeah, but rather, I would like to see it, you know, it's limited in what can go to an ABLE account in any given year. An ABLE account has the Medicaid payback provision, like a first party trust. So generally, you know, we want to see it go to a third party trust. And then you could give the trustee the authority to make periodic transfers to an ABLE account. You know, the benefit of an ABLE is sometimes the beneficiary can get a debit card, and that can be really important for that person's sense of independence and whatever. So it grows tax-free. That's a benefit too, but you can't redirect where it goes when the beneficiary dies. But probably the better protection would be the third-party trust with the ability to make transfers to an ABLE.
I agree with that 1,000%. And one thing that you can't do, so can you redirect some inheritance to an ABLE? The answer is yes, but there's only $15,000 a year that can go into an ABLE account. So number one, so that inheritance is probably more than 15. So that might be a problem. And number two, once an ABLE account balance goes over $100,000, then you can, disqualify from SSI and Medicaid. So an ABLE account shouldn't be over a total of $100,000. You can only have $15,000 a year going into that. So that is the problem with that. And as Lisa said, there is definitely a Medicaid payback on that. Okay. So if a child has a very small savings account, does it still affect the ability to receive or waive program benefits, SSI? Should we close the account? And I'll address that. You can too, but I say no. I mean, again, it's $2,000. They can have up to $2,000 in their name. They have a small savings account. It's not a big deal. When they apply for SSI and Medicaid, it can be paid to their account, or you might be the designated payee and it might be paid to your account. But if we're having small accounts and they're under $2,000, I don't see any reason for closing it out. Lisa, do you have any thoughts on that?
No, that'd be fine. An awful lot of my clients' kids do have those accounts. It's just, it's cumulative. So whatever assets they might own anywhere, cumulative, they can't add up to more than $2,000.
So we do have a question here, and this one might be offline. I may have you just reach out to me, but it says, so they can make $13.10 a month. I just talked to the Social Security office yesterday, and he told me my son can't make more than $70 a month. And I'm assuming he's very wrong. So I think what he's talking about is basically anything, the first $20 they don't count. And then, there's a few things that they don't count, but then they start reducing your SSI. The $13.10, he can make up to $13.10 a month or less, but his SSI would be reduced. It definitely would be reduced. So basically, they're saying if he earns more than $70 a month, his SSI is going to start being reduced. And that is true. He is going to start getting reduced. Okay. And we're, from a time perspective, I'll keep monitoring the chat box, and I'm going to let you move on to your other slides.
Okay. So here, just choosing a trustee is, of course, I think the hardest decision that my clients make if they're choosing a guardian for their child and then a trustee. So the choices are, you can name an individual, a friend, family member. You can have one person serve by themselves, or you can have multiple trustees serving jointly. You can name a corporate trustee. So that's a bank like Wells Fargo has a trust department. Or there also are just trust companies. Northern Trust is one, for example. Another option is the pool trust. In Texas, we use the Arc of Texas Master Pool Trust. And this is a nonprofit where, if you're familiar with the Arc, they're a disability advocacy organization, but they manage a pool trust. Arcs in a lot of states manage these pooled trusts. So everyone's assets are pooled for investment purposes, but your family member's account, they call them sub-accounts, that would be established and funded, would be managed and accounted for separately. So if I say I'm going to put $100,000 in a sub-account for Leslie in the event of my death, then they will pool those funds for investment, but they will manage the $100,000, and her account would get a proportionate share of the investment earnings, and they would charge a management fee based on how much is in her sub-account. And that's what they would have to distribute to her over the course of her lifetime, the term of the trust. There's not a black and white answer, nor is there a black and white answer of whether your guardian should also be your trustee or whether they necessarily should be different people. That kind of is just looking at your family situation. Who are the people you have to call on to fill into some of those roles? What are their skills? Are they organized? Do they have integrity and honesty? Do they know your child? A corporate trustee kind of makes sense. I would say it's not an absolute cutoff, but if you're talking about $1 million or over, that's kind of when a corporate trustee might make the most sense. They charge a fixed rate, usually about 1.25, 1.3%. Maybe you're going to pay your friend or family member to be trustee too. So it's not here you're going to pay a trustee with a friend or family member. You're not. You want to contemplate whether that's a job that you want to compensate them for. The benefits of the corporate trustee is, of course, they are professionals, just like any other thing that you would take your needs to. You want to have someone who's skilled and experienced. there's a lot of risk with an individual. The thing about the trust, a trust, I always say that's why we call them trustees. You have to really trust them, and you have to know that you can trust them when nobody is looking, because there's nobody that will police them. So if you name Uncle George, Uncle George really doesn't have to account to anybody or report to anybody, and no one will come out and say, hey, Uncle George, we want to see how you're doing on that trust. So we've seen some, things happen where somebody just mismanages it, doesn't understand the Medicaid rules, steals from it, so you just have to consider all of those possibilities as you're.
And a trustee's job is a big job. It's not for the faint of heart. It has to be a relatively intelligent person, and especially again, if we're talking big amounts of money, there's a lot of things that need to happen in a trust, and the trust can own more than just money. They might own property. There could be all kinds of other moving parts with the trust. So I do think, special consideration again. But when you work with somebody like Lisa that specializes in this, and they'll give you their opinion on what you might consider. Some people have profound people in their family that they used to be the professor of finance at some prestigious university, and they could easily handle being the trustee. And other people have exactly no one in their family that can handle that. Maybe there's not trust, maybe there's not knowledge, whatever it is. But people like Lisa are definitely going to help you do this. Lisa, what about, I know we're coming around the bend on time, but what about, so if a family, so we have this question, this is a good question. So what if I don't already have a special needs trust? Should I go ahead and change my beneficiaries to the special needs trust? And no, if it doesn't exist, don't do that. But I want you to talk to them about, what if you don't have a special needs trust? What is another door, like for instance, a testamentary special needs trust that might live inside their will or something like that? Can you explain that process to people if maybe they're not ready for that jump of a special needs trust, but they need some kind of protection that if they die, that it will be set up then?
Sure. So generally, that's kind of the two ways to do it. Either the trust can be a testamentary trust, meaning all the terms are in your will. And I always tell my clients who are kind of panicky about, and they realize they need to have this done and they should have had it done last week. I'm like, look at the will you have. It's really likely that somewhere in there it'll say, if any beneficiary is a minor or is incapacitated, then there's instructions to hold their share in trust. So a lot of times there's sort of this savings clause. It might not be exactly the terms you want or the people you want involved, but you might have a safety net that'll let you sleep at night. So we used to kind of give our clients the option, money-wise, hey, if you want to just have this special needs trust created when you die or when the second of parents die, we'll put it in your will. The will then, when it's probated, becomes the trust agreement. All the terms are in that document. That's a testamentary trust. And it really is the same for a lot of purposes. You can name the testamentary trust as a beneficiary. But what we do now, we just made it our standard practice. We go ahead and pull out that special needs trust and do it as a separate standing agreement, primarily because it's so common for grandparents or other family members to want to make a gift. And if it doesn't even get created when both mom and dad are both dead, then nobody else can really direct anything into it. So we pull it out, we fund it nominally with $1. So it exists, even if it doesn't have any sort of investment or bank account associated with it. It's the agreement. It can be identified. It can be named as a beneficiary or as a beneficiary under a will. So
thank you for sharing that.
Sure.
That's important, because some people are in a place they understand that they need it, or they might need it in the future, but maybe they don't need it just yet. But one thing I do want to say is, in that example, if we got grandma and grandpa are leaving money to little Johnny, then that trust needs to be set up. I mean, you can't create a testamentary trust under your will for grandma and grandpa that's leaving Johnny money. So there are some other other considerations that you may want to share with your attorney when you're sitting down with these things. If you have specific family members that may be aging or are sick already, and you already know that they're leaving your special needs child money. Let's see if we have some more questions. If a child has life insurance policy, does it go against SSI? And so the answer is maybe, if it is a permanent life insurance policy. So if it's a permanent life insurance policy that builds cash value, such as whole life or universal life, the assets in that policy could be counted against the child. But a way to fix that is to change the ownership to make sure that you are the owner of the policy. So in that example, Lisa has a daughter. Her daughter, in this example, has a whole life insurance policy. And if it's in her daughter's name, then yes, the cash value in that policy will be counted against her for SSI. However, if Lisa is the owner of the policy, then it won't be counted against her. So there are ways around it. Term life insurance is not counted against a person for SSI because there is no cash value in that. So that is a good question. And then we have another one. This is a good one. Are trusts state by state, or can they go across state lines?
Yeah, so generally they do go across state lines, especially the third-party ones. I think historically there used to be some quirky rules about them in various states, but I think those have sort of gone away. If I know somebody's moving, I will often find a special needs attorney in that state and ask them to review it. And I've done that in a handful of states, and it's always come back that the trust is fine. So I think with a third-party trust, there's this general universal acceptance of them. The first-party trusts are a little different. Some states do impose additional restrictions on those.
Okay, let's see. One of the things, so Lisa Wilson's office can definitely help you with your special needs trust, whether it's first party or third party or both. They can also help with guardianship. Is that right, Lisa? Are you well versed in that? Because this is something that we're hearing all the time: guardianship versus supported decision making versus power of attorney, healthcare power of attorney. And I actually believe that we did a guardianship webinar with you before. So we have that on our YouTube channel. So these are some things that, maybe should be on your radar. We've hit on a lot of them. And the thing is what we said at the beginning is when it comes to special needs planning, there's a lot of things to consider. And this whole, webinar is on special needs trust, but we start dabbling in SSI and SSDI and other things and guardianship, and we're talking about all of these things, and all of these things, ABLE accounts, they're very, very important. And what I will say is that just, visit our YouTube channel, tune in, watch your emails. We will definitely put out any additional webinars that we're putting out there, but our YouTube channel is chock full with other webinars. So if you want to go deep and wide on the waivers, or you want to go deep and wide on SSI, SSDI, deep and wide on ABLE accounts, you can have at it. You can kind of pick the ones that might be most relevant to you and your situation. So we've got the contact information here. So Lisa Wilson, Hazen Wilson, Allison Scalbert Consolidated Planning Group. We're happy to help you any way that we can along your journey. And we know that we have people on here. Everybody's situation is a little bit unique. Somebody might be going through a divorce. Somebody may not be. Somebody may already have a special needs trust, and maybe it was done a long time ago. And maybe you want, maybe it was done by an attorney that didn't have any background in special needs, and you need somebody specialized to look at it. Maybe you just don't even know what to do on guardianship. You're hopeful and optimistic that your child's going to get there, but they're not quite there yet. And you want to know about some other options like partial guardianship. Lisa's your girl. She can totally help you with all of those things. So if you have anything that's kind of overwhelming you, definitely reach out. We can help you any way that we can. We're happy to. Lisa, thank you so much for being with us today. You're so smart, and you bring so much knowledge to us and help us navigate the confusion between first party and third party. and testamentary.
Thanks
So,
for the opportunity. Appreciate it.
so much. And Veronica, thank you again for having us. We're always glad to be back with you. And if we can be of service to you any further, certainly let us know.
Yes,
Thank you so
thank you.
much for all your information, Lisa and Allison, and see you guys in the next one. Thank you so much.
Okay. All
Thank
right.
you.
Thank
Take care. Bye-bye.
Bye-bye.